So this is our second screenshot video in our last 2 weeks for crime. So this will be our last screenshot video. We're in the midst of talking about procedure in New York for criminal cases. The next topic is motions to suppress evidence and motions to dismiss charges. What I want to say, however, is that what also is going to be happening in a criminal case, the defendant has been charged. The defendant now has a lawyer. That lawyer is going to be exploring the possibility of a plea bargain. The lawyer also is going to be pursuing something known as discovery, which is a process whereby the defense is given evidence and information by the district attorney's office. And so at some point, the defendant may plead guilty. And you're going to see a lot of that if it's kind of a low-level routine charge. I think that we could say the more serious the charge, probably more discovery will be forthcoming. In some cases, we're going to see a motion to suppress evidence and a motion to dismiss charges. They're two different motions. A motion to suppress evidence is based on the claim. By the way, a motion, I should say this, a motion is when a party to a lawsuit, in this case the defendant in a criminal lawsuit, seeks some type of judicial relief. And here the defendant is asking the judge to decide to order the prosecution not to use certain evidence that was obtained from the defendant. And so that's why it's called a motion to suppress evidence. And such a motion is going to be predicated on the claim that the method used by law enforcement to obtain the evidence against the defendant violated one or more of the defendant's constitutional rights. If there's a successful motion, we shouldn't think that it will necessarily automatically, there you go, lead to a dismissal of the charges. It may result in the dismissal of the charges if the government needs that evidence to obtain a conviction, but possibly the government can, if you will, live with the loss of the evidence because there's other evidence that permits the government to ask a jury to convict the defendant. For example, if a confession is suppressed, the government may very well have all kinds of other evidence to show that the defendant is guilty, or to argue that the defendant is guilty. We're going to just take a look at three, in a very general way, you could do a whole course on this, three different types of motions to suppress. One motion is based on a search and seizure conducted by law enforcement. A second would be one to suppress a confession given by a defendant. And third, a motion to suppress identification evidence. A motion to suppress evidence on search and seizure is based on the argument that there was an unreasonable search and seizure and under the protections of the Fourth, if it's the federal government, or the 14th, if it's the state government, the Constitution, according to the exclusionary rule crafted by the Supreme Court, should not be able to use the evidence. So, typical kind of case, the police pull over a defendant's car, search its interior, and discover drugs. The defendant is going to be bringing, his or her lawyer is going to be bringing a motion to suppress evidence, and it's going to then depend upon how the judge looks at the particular facts and circumstances. Why was the defendant's car stopped? What was the factual basis of any suspicion there may be drugs in the car after the car was stopped? Why wasn't there a search warrant obtained, etc.? A second motion to suppress is based on a confession, and that calls into play the 5th, 6th, and 14th Amendments of the United States Constitution. Most of us have seen in those dreary procedural cop shows on TV, Miranda versus Arizona, and that was a famous, in some circles, an infamous case decided by the Supreme Court. I think it was 1966. I was a student then and remember reading it fresh off the press. But in any event, basically Miranda says if a person's in custody, so first of all, if you're not in custody, you're not entitled to your Miranda warnings. But if a person's in custody, before that person can be questioned, that person must be given his or her Miranda warnings, and you know what they are, or waive them. And if a confession is taken from that defendant in custody and Miranda hasn't been observed, then the confession will be suppressed. There's another possibility, and that is the confession may have been involuntarily obtained, in which case it's a different analysis than Miranda. If a confession is beaten out of a defendant, then that defendant could have had the Miranda warnings read to her or him by a bishop, and it wouldn't matter. The fact is, if it was involuntarily taken, coerced physically or psychologically, then it can be suppressed. The third type of suppression motion is directed against identification evidence, and I can't help but think very quickly of the arrests that have been predicated recently based on the rioting in the nation's capital on January 6th of different individuals who decided, hey, not only is it a good idea to break the law, not only is it a good idea perhaps to beat up on a cop, not only is it a good idea to break into offices, but you ought to do that and put up a selfie on one of your social media platforms. So in that case, all bets are off. That's not when a person's identified by a selfie. There's a part of this that just is hilarious to me. A guy who was sitting in the Speaker of the House's office with his feet up on the desk. He's like the cat who swallowed the canary, and he's in pretrial custody today. So cheers to him. But in any event, it's got to be arranged by the police, and there's a different rules that have to be followed. If there's a lineup, it's got to be fair. So if I'm a suspect, don't have the other people in the lineup look like they're 6'2" and 30 years old, because I'm a lot older than 30 and I'm about 5'9". If it's a show-up, which is a one-on-one confrontation, it's got to be conducted soon after the crime has been committed or a witness is about to die. If it's photographic identification, again, arranged by law enforcement, so the selfie social media stuff doesn't apply. It can't be unduly suggestive. So that sort of sums up motions to suppress evidence. And again, in not all criminal cases, but in some criminal cases, we're going to see those motions. If they're successful, it may or may not lead to a dismissal of the charges. But then what we have are outright motions to dismiss the charges. And I've just identified 5 of them, or 5 different categories. There's more, but this will give us a sense. It could be, if there's an indictment, that the evidence that was placed in front of the grand jury when the judge looks at it is insufficient. And that would mean that there was no evidence introduced that would have supported one or more of the necessary elements of the crime charged. Years ago, when I worked for a judge, I would look at grand jury minutes. That's the stenographic record of what happened. What did witnesses say? What evidence was introduced otherwise? And I just would have a template of here are the charges, and when I saw evidence that hit an element, I would check the box. If there was a box that wasn't checked, I'd reread it. And then, of course, I would bring it to the attention of the judge who made his decision. I might add, independent of my analysis. Okay. If the indictment is dismissed for insufficient evidence, by the way, I always used to say to people when I did criminal defense work, let's not have the big party yet, because the prosecution can go back to the judge and say it's got new evidence they want to put in front of the grand jury, and typically the judge will permit them to do so. Could be that the charge is barred by double jeopardy. I've been following a little bit the trial in Minneapolis, Minnesota, against where a police officer is charged with basically killing a man by what happened during the arrest and the force used at the arrest. And there came for the prosecution a perilous or a dangerous point last week when one of its experts seemed to allude to a report that the judge said had to be kept away from the jury's attention. And had the judge declared a mistrial on the ground that it shouldn't have been presented to the jury, and then the prosecution were to recharge the defendant, the defense could argue that even though in most instances a mistrial just can lead to a new trial, if the mistrial was brought about by the misconduct of the prosecution, then it cannot proceed because of double jeopardy. So there would have been room at least to make that argument. We could have, under the applicable statute of limitations, a charge that is untimely. Statute of limitations is more important in civil cases than criminal cases. When I say more important, maybe I should say it comes up a lot more often. But typically in New York, there's a 5, 2, and 1, 5 years for a felony, 2 years for a misdemeanor, 1 year for a violation, no statute of limitations for A felonies. So that, again, typically isn't going to come up because most people who are charged with a crime, if you stop and think about it, are charged with a crime soon after the crime is allegedly committed. But it's there, meaning that's a ground for dismissal. Another ground, which used to be a lot more fruitful for defendants back in the day, is that the defendant has been denied the right to a speedy trial. In New York, we have a double-barreled right. One is based on the Constitution's Sixth Amendment. The other one is based on a law set forth in Section 30.30 of the Criminal Procedure Law. What I've noted over the years in state, or what I've observed, better said, over the years in state and federal court, is so much more attention is given to this right that we're seeing fewer and fewer instances where the right has been denied. I'll leave that at that. The last one is a statute under which the defendant is charged on its face, meaning as it's written or is applied to the defendant, is unconstitutional. And we can talk very briefly as we near the end of this video of the movie People versus Larry Flynt, who recently died. He was an American pornographer. And in the early parts of his career, he was charged in many different states with violating the obscenity statutes. Some of the stuff that he produced was pretty raw, shall we say. But a lot of the charges against him were dismissed. And by the way, there was a great Buffalo lawyer at the time, Harold Price Farringer, who then went to New York City, and his protege, who's still around here, and a great criminal defense attorney, Paul Cambria, and they had a lot of the charges, or were able to have a lot of the charges dismissed on the ground that either the statute that was written, as it was written, or as it was applied to Flynt's stuff, was unconstitutional because it violated the First Amendment right to free speech. Okay.